The corruption case against former National Assembly Speaker Nosiviwe Mapisa-Nqakula has been postponed to the 4th of April. Her legal representatives accused the state of giving them the runaround over the correspondence between the investigating officer and the prosecution team. She faces 12 counts of corruption, 1 count of money laundering, and is accused of accepting bribes worth over 4 million rand. Our reporter Sitheliswa Beja was in court and filed this report.
Corruption accused Nosiviwe Mapisa-Nqakula's lawyers have berated the state for sending them from pillar to post. Mapisa-Nqakula appeared in the Pretoria High Court on Friday. The case was postponed in January for the state to build its opposing argument. The defense says after weeks of deliberation, the state has not disclosed Section C of the police docket, which is the correspondence between the investigating officer and the prosecution team.
You'll recall on the last occasion it was very, very clear in and out of court that C was tendered unequivocally. And we say on the last occasion it was an effective withdrawal of opposition. However, my Lord, in the last number of weeks there's been an about-face by the state. We don't say that's Mr. Lowe. Now they refuse to grant us the C section. Their basis, as we understand it, and it's articulated in those letters that were attached to the practice note, is to the effect that we haven't made out a case. My Lord, there could be nothing further from the truth.
Defense attorney Reginald Willis believes the state has something to hide.
If you look at the effort with which the state has resisted our client and ourselves, and then on the last occasion tendering everything, then giving us B, and now going back on giving us C. Well, it's difficult not to infer they're hiding something.
The defense believes that Mapisa-Nqakula's arrest was politically motivated.
One of the central complaints was the way our client in a period of 2 weeks, just over 2 weeks, was harassed, her home raided. This is now coming after they've sat, apparently having investigated and finished an investigation, all to pressurize her into handing herself over.
It has also questioned the key witness indemnity.
One is dealing with Mapisa-Nqakula, who is the 204 witness in this matter. Now, it is our case that the 204 certificate that she was granted made it impossible for her to be indemnified in this trial because there was a failure of its drafting.
Meanwhile, the state argues that the information contained in Section C is confidential and will not be used during the trial.
The prosecutorial discretion is criminal discovery involves making critical decisions about disclosure, timing, scope, and management of evidence. The NPA's Code of Conduct is very clear. As soon as possible, we must release, disclose to the accused any prejudicial and beneficial information. And this is the right to a fair trial is a very important right, and it's a continuing duty until the end of the trial. Is the C section the only source of evidence? The answer is no.
The matter will return to court on the 4th of April 2025, while Mapisa-Nqakula's bail is extended to the next appearance. For Newzroom Afrika, Channel 405, I am Sitheliswa Beja in Pretoria.